May I have your lordship's leave to mention a matter? I mean, it's a section 19 appeal, section 19 of the Contempts of Court, for inclusion in the list any day after the vacation. Grateful.
So may I permit to mention one relaxation of conditional bail after vacation? Call the list.
Has the list been called, Lordship? Yeah, I'm for the petitioner appellant. There seems to be some
We'll
defect.
correct we give directions on that.
Number 1.
Defects be removed, report be filed, adjourned 2 weeks after vacation.
Obliged, my lord.
Item number 2.
If you give action to and send it from mediation, never give any not sentence and taken.
My investigation part I cannot say because he is an accused.
Who is in it?
The writ petitioner is an accused. Because everything has happened because of the statements made by him
Okay.
or her.
Nowhere it has been alleged that writ petitioner has made any comment. He has been.
That part.
He was hauled for clapping.
That is the
Some lady made comment. She was walking aside and clapping with slogans.
But you are an accused in that case. All right.
Only one line to your lordships whenever. But we have asked that metadata of Facebook to place those videos down. But that takes time. Judicial is fast to that score. But it will be easier for us to communicate the same.
Where is your prayer for that?
But I have, it's in my case diary, itself.
You have to make that prayer in your report. That this is directed. We request you to make a direction in aid of investigation.
They have received that. They have sent us acknowledgement, but they are in process of
who are
Meta Facebook.
My lord, we have sent it.
So why, Mr. Additional publicity, this report should include that fact and ask for a direction upon Facebook Incorporated or the nodal officer who is there in India. On the next day, you make that prayer. Report is accepted. Report is placed on record. Report shows Srimati Sujata Kumar Binapani, IPS. Record shows sit Special investigation team has taken over investigation. Inspector Subhash Jana, officer in charge Cyber Patrol Cell, CID, has been included to assist the SIT as cyber expert. Steps have been taken to trace the origin of the offending on video which was uploaded on a social media site. Further report be filed on the adjourned date. Matter will appear on 8th of January. Now, in view of the ensuing winter vacation, we direct the matter to appear on 8th of January 2025.
Your Lordship, I appear on behalf of the state, Your Lordship. My camera, for some reason,
ওখানে পাচ্ছো has been nominated. ওইখানে লেখা আছে যা next Chief has assigned it to municipality. এটা কি mediation report failed na same order as in one, right? Two. Next, এই corrections গুলো যা যা আছে করে দেবে 3, 4, 5 whatever corrections incorporate.
Six, my lord. There is a need of my lord. In the satisfaction portion, my lord.
ওই satisfaction change করো
এই সিজিএম হবে, সিজিএম করা আছে।
correct 6, 7, 8.
হ্যাঁ অ্যান্টিবেল না 6 এ অ্যান্টিবেল না বেল দেবী
Seven. Cost item and order শুধু নাম ভুল করেছে। না, 7 ই না।
এইটা কি হয়ে গেছে? এইটা
9.
এই যে 8
petitioner, my lord. I am for the petition. Well, on the last occasion, your lordship asked for a report
Yes,
from the CBI, my lord. Your lordship asked from the report regarding that.
My first contention is that against this petition of proclamation warrant an attachment has already been made. We have made the compliance report. And lordship, so far I am judgment of the Honorable Apex Court, Russian paragraph 25, this anticipated bail application is not maintainable.
What?
Lordship, as because proclamation warrant as well
that we know, that is all right.
and we have the compliance report, Lordship, will see very last page of the
You surrender.
My lord, so far as the proclamation is concerned, my lord, may I submit, my lord, subject to lordship's correction. But there is a recent judgment of the Honorable Supreme Court where it has been stated it is not an embargo in all cases.
Correct.
Sacrosanct.
But in a murder case, it's an embargo. Okay. If it's a 420 case, it is not an embargo. Because proclaimed offender under the old act and the new act, there's a specific band of offenses for which you can declare a person as a proclaimed offender. 420 will not be one. 406 will not be one. But 302 will definitely be
But
one.
two accused persons have been granted bail.
Correct, but
This
they
petitioner was not
have
really
granted what?
your bail, my lord.
Bail.
But
So
initially, he was not.
you
my lord,
will also be
charged.
granted bail. Petitioner is a proclaimed offender in view of his petitioner did not cooperate. Petitioner contents co-accused have been granted regular bail. He has been falsely implicated. He prays for anticipatory bail. Learned lawyer for CBI submit petitioner did not cooperate with investigation. He is a proclaimed offender. Application for anticipatory bail is liable to be rejected. We have considered the materials on record. Allegations involve statements of witnesses show petitioner was a member of the mob who
petitioner conspired, hatched conspiracy thereafter after 4 or 5 days incident.
all right. Statements of witnesses show petitioner is a conspirator to the murder. Full stop. He had absconded and has been declared as a proclaimed offender. Co-accused have been released on bail. It is tried. Parameters for grant of bail are different from that of pre-arrest bail. Prayer for pre-arrest bail requires assessment not only of the nature, gravity of offense, nature of evidence collected against the petitioner, but also his conduct during investigation. Petitioner is a proclaimed offender. There are materials implicating him in the conspiracy. Hence, we are not inclined to grant anticipatory bail. It is open to the petitioner to appear before the jurisdictional court and pray for regular bail in accordance with it. Next.
My lord, I am for the petitioner. My lord, this matter, my lord, petitioner has obtained the work order, my lord, the report, my lord, Dr.
Yes, Mr. A.
My lord, on the last question, your lordship was directed to file a report.
Yes, has he done the work?
My lord, work is completed here.
All right.
In the,
Refund the amount.
my lord,
Refund the amount.
My lord, 5,12,553. My lord, kindly make some installment, my lord. My lord, at least 2 installments.
We are keeping it up 2 weeks after vacation.
My lord.
In the meantime, report is placed on record. It appears that from the report is placed on record, report shows petitioner had executed the work order, but materials show that the work order had been issued to the petitioner without following procedure, without following due procedure, and petitioner had wrongfully gained from such illegal exercise. Without prejudice to rights and contentions, petitioner proposes to refund the amount allotted to her in execution of the work. Petitioner is at liberty to deposit a sum of rupees so and so allotted to her in connection with the work order which was illegally awarded full stop, before the trial court, before the jurisdictional magistrate or jurisdictional court within 1 week after vacation. Report be in the event the amount is deposited, the same shall be kept in a recurring fixed deposit account maintained in a nationalized bank, subject to the result of the litigation. Subject to the aforesaid, petitioner shall not be arrested in this case for a period of 2 weeks after vacation or until further orders, whichever is earlier. Matter will appear 1 week after vacation. Next.
Milord, I am for the petitioner. Milord, I have deposited the amount. Milord, the
Petitioner has deposited half of the bill for unmetered consumption.
no, Milord, no. Milord, there is an allegation that the petitioner being a pradhan.
All right. Petitioner has deposited the without petitioner contents without prejudice to his rights and contentions. He has deposited the misappropriated amount before the trial court. This is not opposed by learned lawyer for the state. Under such circumstances, we are inclined to grant anticipatory bail. Report is placed on record. Next.
Yes, Lord, my application, Lord.
Well, based under the Electricity Act, my lord, he has deposited 50%.
Petitioner has deposited 50%
of the
of the
final
bill,
assessment.
final assessment bill for unmetered consumption to the tune of so and so ache. Accordingly, we are inclined to grant anticipatory bail. Next. 15.
The petitioner lordship, last occasion you lordship wanted to see the postmortem report lordship.
Suicide?
Continuous, that is.
All right, we have the postmortem report is filed. Postmortem report shows the ligature shows that the ligature mark is non-continuous and obliquely placed high up on the neck, which is indicative of suicidal hanging. Statements of witnesses, the allegation of torture are general and omnibus. Under
Lordship, again says them that they have put a rope against her and they have pulled her in the whole house. This is the brother-in-law. Is the one.
all right.
Said within 5 years of marriage.
Acha, allegation of strangulation. Allegation of strangulation does not find support from the nature of injury noted in the postmortem report. Under such other allegations of torture are general and omnibus. Accordingly, we are inclined to grant anticipatory bail. Next.
Well, I'm for the petitioner.
there before your lordship?
Tell us, tell us.
Okay, sir, please
But
allow.
tell us.
My lord, so far
the
as
report
petitioner
that
number
we are-
1 is concerned,
Report.
antecedent list. এটার উপর কেন করলে? এটা original. হ্যাঁ, report দুটো দিয়েছি। কালকে না, আগের দিন।
Not today, not today.
Okay, Baba.
Next. Come on. Report.
দেখো,
But 74 of the BNS, that is 354,
Yes.
1.5 year relationship,
We have
thereafter
considered the
breakup.
materials on record. There was a romantic relationship.
Direction, my lord, service.
There was a romantic relationship between parties. In light of the aforesaid, we are of the opinion custodial interrogation of petitioner is not necessary and he may be granted and suit reason. Next.
Sorry.
All right, এই করে দাও তো opposite. Next.
A commercial transaction.
One give it.
Please.
This is our opposition. Last occasion, your lordships directed.
But 26, my lord, will please see paragraph 8 and 9. And then, my lord, will please come to page 28. Oh, I don't know. But please comes to para 8 and 9 at page 19 of the 156.3 application file.
What was supplied to you?
Well, iron steel.
TMT bar.
TMT bars is there.
TMT bar.
Yes. And please comes to page 28. The payments made since 2018. Now the dispute relating to about 3 crores 5 lakhs, 50 lakhs. So that's the dispute.
All right.
But prior to that, on the 5th, they say from 6th of April, from 5th, your lordship will see payments have been made to them. And I've annexed all the certificates of them.
Now let us do like this.
Yes, madam.
We keep this matter after vacation. Your petitioner cooperates and places on records all relevant documents to the investigating officer. All right, Mr. Mukherjee?
Yes. So keeps it 2 weeks after vacation.
2 weeks after vacation.
Okay, so in that meantime, no arrest.
One senior advocate versus 2 senior advocates.
Justice Mr. Ganguly hasn't come. He's the main leader.
He's leader.
So people,
He got a bad order in the morning.
I know. No, that was a.
He's smarting. He's
He
smarting.
knew it was a disorder.
What is your problem?
But we want to place some more document.
To place it to the investigating officer. How many oppositions will you file? One drafting not enough. Huh?
But our entire case is this,
Supplementary, another supplementary. One was for Mr. Ganguly. One will be for Mr. Mojumdar.
And one for
will be
Mr. Bhatt.
Bhattacharya.
Malad, the irony is 3 of my chamber juniors are here.
Then
Mr. Ganguly, Oyan Bhattacharya, Minoti Gomes.
I'm for the state.
That is 3.
What state? All right, Ms. Gomes, he will produce documents and also whatever documents will be produced.
They will also produce that.
De facto complainant, and if necessary, you come up. It appears to be a running transaction.
But it's a separate cause of action
Maybe
altogether.
separate cause of action. Appears to be a running transaction from 2018. Let them produce the documents, and if necessary, we'll send it for mediation for settlement of
Yes.
accounts. Petitioner contents, he deals in, what are you?
Well, at Sand Commodities, I am Milan Agarwal.
Milon Agarwal, what does Milon Agarwal do?
Well, he's the partner of that company, Sand Commodities.
What commodities?
SAN.
Sand commodities. Petitioner contends that he is a partner of petitioners content, they are partners who carry on business in iron and steel. There is a continuing transaction since 2018. Full stop. Subject matter of the instant case deals with a with a consignment of bars, iron bars supplied by the complainant, which was found to be substandard. As a result, payment was stopped. In retaliation, criminal case has been registered. This is the supplementary affidavit is filed by the complainant. This is denied and disputed by the complainant, who filed affidavit in response to the bail application. Keeping in mind the nature, the profile of the accusation and the contentions made on behalf of the petitioner, we direct the petitioner to meet the investigating officer and produce relevant documents with regard to the transaction in question. De facto complainant shall also be at liberty to produce documents in support of their accusation. Matter will appear 1 week after vacation.
Make it 2 weeks, man.
2 weeks after
They are in
vacation.
Orissa, so for 2 weeks.
But one humble submission. But there is a angle of portrayal also, because that's what they, when they came to us, they have shown us some document agreement with Odisha government, which says they are authorized to not supply the TMT.
Otherwise, also you would have supplied. Otherwise, let us, Mr. Mojumdar, he says that we are not going to supply Odisha government, but we are going to supply general people of Odisha. We will sell as a retail sale. Will you have not supplied or not? What is this? Did you make any monetary concession at the rate at which he was given the TMT bars? You
No.
did not. Then you further report your Christmas present. Further report by police. 2 weeks after vacation, matter the petition subject to petitioner shall not be arrested in connection with this case for a period of 3 weeks or until further orders.
Which is
was
a
earlier.
great-
Now another affidavit, etc. Fine. Yes, all
As of
affidavits
these
to state. আরে দেয়া আছে বলবে যে notify in terms of order dated so and so. Next.
My lord, I am for the petitioner led by Mr. Paul. My lord,
I know, I poop. He's the problem. And
my lord, I am for the petitioner. My lord, in this case,
who
there is,
committed suicide? Huh?
my lord, in this,
Husband.
no, my lord, in this case, there is a delay of 6 months, 13 days in
That is
lodging the
all right.
complaint. And my lord, charge sheet submitted under section 306.
He has poured poison. Where is the statement of pouring poison? Anyone saw pouring poison?
161, 164, my lord, one eyewitness has seen these loss. But one thing is, my last occasion in your lordship, asked me to appear the investigation officer, why he has not included some 302.
Huh?
That
Yes.
I also asked you.
Right.
I asked my investigation officer.
If this is the 164, it must be 300.
Their explanation is that, my lord, they have, prior to the 164 statement, they, in the CDA, the person concerned who has administered poisons and the victim, they are in the different location. They have,
We cannot understand what did you say.
prior to the 164 statement, the CDR, I will, last occasion, I don't put the CDR, we just,
CDR, what will CDR show?
location of the victim and the person who concerned administered poison in the eyewitness. They are in the different location at the material time. One is Horubnagar, another is Bhaduria. According to that, they disbelieve the 164 statement. Not only that, other
But
aspect of-
will you be confident that the mobile phone is always with the victim?
that I told my Mr. Officer, ignore it.
We add 302, you might have an alternative 306, but then you should add 302 after this 164. How can you deny? Our contention is this. If it is not a case of 302, it would be alternatively, you can go ahead with 306. But in this case, with a 164 like this, to ignore 302 just because of a tower location, is you are disbelieving an eyewitness in light of corroborative evidence with regard to presence. There is no proof that a person will always carry his mobile phone, right? Until and unless you have independent witness, yes, he was working there, he was present there, then there is a witness versus witness. We will direct you to add, we are rejecting his prayer. We have considered the materials on record. Statement of witness before magistrate discloses that petitioner had poured poison in the mouth of the victim. Victim died due to poisoning, full stop. We direct the investigating officer is present. We direct the in light of the aforesaid, investigating officer is present. In light of the aforesaid, we direct the investigating officer to submit supplementary charge sheet in under section 302 IPC against the petitioner, keeping in mind the gravity of the offense. We are not inclined to grant answer. Yes. This is the CDR is cannot be given so much importance, sir. Next.
I told them.
Santosh Singh. Santosh Singh. We couldn't and we couldn't give you not to arrest yesterday.
2 persons suffered gun
Other
injuries.
matters which we failed, we have given not to arrest after vacation.
2 persons suffered gun injuries on the night of 29th of August. On the following day, those 2 assailants were arrested by the police, and according to their leading statement, my lord, arms, ammunition, everything was seized.
No, Mr.
But they got, my lord,
You will get bail, not you are a gun dealer. We have considered the materials on record. Petitioner is involved in the offense. We have oh, he fired.
No. No. But
We have considered the materials on record. Petitioner is involved in the offense resulting in in the crime causing gunshot injuries on the victim. Keeping in mind the nature of the crime, we are of the opinion this is not a fit case to grant anticipatory bail. Sorry, next.
Well, I am for the petitioner. Allegation is under section 498A 304B. As per the instruction, husband was arrested and was granted bail by the learned lower court below. I am the
You are what?
married sister
You
in
cannot say lower court.
court.
You should. There is no below above. So it is trial court or jurisdictional court. All right. Yes. What is the how many years after marriage incident occurred?
2 years.
We have considered the materials on record. Petitioners are the in-laws of the victim lady. Allegations of torture are general and omnibus. Keeping in mind the aforesaid fact, and as custodial interrogation for progress of investigation is not necessary, petitioners may be granted anticipatory bail. Acha, principal accused, that is husband, has been enlarged on regular bail. Next.
Mallet, I am appearing on behalf of petition.
Document doesn't have the instruction whether husband is on bail or not.
Although the kid husband bail. Husband has been arrested too.
Yes, my arrested.
Principal accused, that is the husband is arrested, has been arrested. Yes. All right. Next.
Mallet, in this matter, I am appearing on behalf of petitioner Mallet. Case under section 306, 318, 4, 16, 2, 3.
All right. You are involved in misappropriation of money.
Mallet.
Then
Yes, Mallet. This in FIR, just that is there is a no constructive allegation against me. I am the part.
Kindly see another statement included, page 14. He have been charged and he is supposed to take care of everything. Now he comes out, try to come out clean that yes, I have sent out so much emails and this thing and that. Ultimately, the hub in charge is the place, I mean, the person who reports. Why didn't he report previously?
Mallet, kindly give a look to annexure P1, Mallet. From August 31st August, each and every time several times I intimate my office superior and my immediate boss, Mr. Shagatar. Even after
where are the reports?
Annexure P1, page number 10, I have started to mail that there is some discrepancy. So I could not open the CCTV footage. And 31st August.
What money was stolen?
Yes, my lord. Whatever. I also mentioned it in
shortfall in every day they were supposed to give this money back to the headquarters.
There was a shortfall.
Even my lord.
And the whole, I mean, the finance department came in, and ultimately this was lost.
My lord, kindly give a look to page 13, my lord. I also page 13 at a CCTV, my lord. Page 15. Yes, my lord. Page 15. I also inform Mr. Shagor Das, who is my immediate boss, my lord.
Yes. Let us. Who has those lines? Sure. There's no hurry. Username column will have
some missing there.
My lord, regarding shipment.
Please, sir. Yes. Tell us.
And my lord, kindly give a look to annexure P3, my lord. I am the first person who rushed to police station to inform that all the discrepancy happens in my office. After that, after 2 months, now office says, as I am having charge, I have responsibility to dissolve all the liabilities. For my responsibility, I several times inform all of you, but you never ever heard me once.
Where is Tonoy Das and Prasad Karmakar?
My lord, Tonoy Das, the person against whom I mailed this Shagor Das. As per my information, there is some relation between Tonoy Das and Shagor Das. And what about Prasad Karmakar? I do not know, my lord.
What some relation?
My lord, as per my information, there is some Mama Bhagna relationship. My lord, kindly give a look to my annexure page number 17 and 18, my lord.
All right. Petitioner submits that he was the head of the hub, wherefrom alleged misappropriation took place. He had promptly reported the matter to superior authorities and had even lodged a report to the police. Belatedly, he has been falsely implicated in the alleged misappropriation. Learned lawyer for state opposes the prayer. We have considered the materials on record, including annexures to the petition. The annexures show there were electronic mails sent by the petitioner. Acha, de facto complainants firm carries on logistics business, and petitioner was in charge of the hub at where was this place?
Dom.
At Dom. It is two employees, namely Tonoy Das and Prakash Kormokar. Prasad Kormokar were working under him. Noticing discrepancies, petitioner had mailed his superior and had even lodged report disclosing report, full stop. No investigation has been made with regard to the roles of Tonoy Das and Prasad Kormokar. On the other hand, petitioner has been implicated primarily on the ground that he is in charge of the
all three are required. Investigation.
No investigation, Corona. Petitioner has been implicated on the ground that he was in charge of the place of business. However, he has placed on record steps taken by him with regard to, in respect of the alleged discrepancies even prior to registration of FIR. Allegation of conspiracy between petitioner and other co-accused must be viewed from that prism. Under such circumstances, we are of the opinion custodial interrogation of petitioner may not be necessary, but he requests to cooperate with investigation in accordance with law, meet investigating officer once in a week on further orders. Next.
One Jibondeep, my lord, he forged, my lord, 2 deed of gifts, my lord, from one Dibbendu Bikash. Thereafter, my lord, Jibondeep sold the property to me. I purchased it against a consideration.
By making a forged deed, gift deed, and if you had a sale deed on the same day, the same place, this is the
How do you establish his conspiracy?
He was,
but I have purchased it.
On the same day, my lord, these 3 deeds were executed on the same place.
Same day.
But
can you see the
first, he executes 2 deed of gifts.
We have
but kindly consider, I have purchased the property by
contents that he is a purchaser of the property against valuable consideration. However, materials on record show forged gift deeds were purportedly executed on the very day the sale was effected in favor of the petitioner. In view of this suspicious circumstance, we are of the opinion complicity of petitioner in preparation of forged gift deeds is evident, and this is not a fit case to grant and suit reversal. Next.
But I pay for this. 2 plots of land, kindly comes to page 16. 2 plots of land, 4155, 5257 and 4155.
Earlier back, has been rejected.
But another co-accused has been granted. Same footing, I have been granted. But kindly sees one document. But kindly sees one document. Kindly sees page 16 of the anticipatory bail application. 2 dark numbers have been identified.
16.
Page 16. 4155, 5257 and 4155, 5114. Lordship would kindly see at the bottom of that page. Jail number 39, Mouja Krishnapur, dark numbers, 2 dark numbers have been given. But in which the alleged cannabis cultivation was taking place. Kindly comes to page 30, page 14. I am Mutibur Rahman. My dark number is 4155/5115. My lordship would see at the left hand side at the top. So, these plots of land are not the plots of land where the cannabis cultivation took place.
Right, my lord. It is completely matched, my lord.
But I have
jail 39,
but
44 and my lord 51.
my plot of land is 5115. But this is obtained from Banglar Bhumi.
Motibur Rahman, third name, my lord, the number, my lord, can you see? 5144.
But my plot of land is 5115.
Where is Motibur Rahman?
Well,
Third name.
third name.
No,
Oh, আমার টোটটা।
the third name, Matibur Rahman, jail 39, plot my lord. Petitioner submits that he is not the owner of the plot where cannabis cultivation was undertaken. He refers to page 14 of the petition. However, learned lawyer for the state produces the case diary enclosing the record of rights. Record of rights pertaining to the relevant DAG, that is DAG number 4155/5114, shows petitioner is a co-owner of the plot. There are materials to show illicit cannabis cultivation was undertaken in the plot. Under such circumstances, we are of the opinion this is not a fit case to grant answer. Next. Cannabis. CANNABIS. Next.
May I please, Your Lordship, my application. My lord, 316, 318, my lord, 420, 406, my lord. FIR says that, my lord, আমার নিকট আলু নিয়ে আসে ব্যক্তি ব্যবসা করে তারপর
Consider the materials on record. Allegations involve a civil dispute over sale of potatoes. Keeping in mind the nature of allegations, we are of the opinion custodial interrogation is not necessary and petitioner may be granted and suitable bail. Meet investigating officer once in a
my lord, leave may be granted to correct the collateral. It will be SEJ, my lord. Great.
Next.
Lordship, 419 is 304B, 6 years of marriage. Petitioners are father-in-law, mother-in-law, husband is
How
in
did she
custody.
die?
Bad injury, accidental one.
We have considered the materials on record. Petitioners are the in-laws of the victim housewife. Allegations of torture are general and omnibus. Incident occurred 6 years after marriage. Under such circumstances, we are of the opinion custodial interrogation for progress of investigation is not necessary. And acha arekta line daw. It is noted in the medical papers that the victim suffered accidental burn injuries. Custodial interrogation is not necessary according. ওই ইনসিডেন্টের জায়গায় এটা দিয়ে দেবে। নেক্সট।
But I am for the
Opposite
petition
student.
also, my lord. But 498A34 entire family has been implicated in the omnibus allegation. No
We have
injury.
considered the materials on record, allegations of torture, general and omnibus. Custodial interrogation for progress of investigation is not necessary. Who is the husband?
Husband is the.
Petition number 1.
Petition number 1, Lord.
Accordingly, we are inclined to grant bail subject to condition. Petitioner number 1 shall meet investigating officer.
Deeply obliged.
My lord, 142 of the BNS Act, my lord, the victim has been recovered and the principal accused one, Prosenjit Biswas, who was arrested and subsequently granted bail by the learned court below.
This person also there, my lord, is a 164 statement of the petition. My lord, victim.
These
So
persons are
they
not named in the FIR.
They are not known to him.
All right. Petitioner contends that he is not the principal accused. Victim has already been, not the principal, he was not named in the first information report. Victim has already been recovered. Under such circumstances, we are inclined to grant ancillary bail. Then come.
Obliged.
Next. Yes.
164 statement of one of the ex-employee whom he has sold the batteries and asked him to bring the money, like 20,000. Forgery, cheating and theft is record.
We have considered the materials on record. Petitioner had misappropriated
Sum of rupees 2 lakh
60,000. Sum of rupees 2,60,000 and other articles.
Forged the bills.
And other articles. Custodial interrogation for recovery of stolen property is necessary. Under such circumstances, we are not inclined to grant ancillary bail. Rejected. Next.
Our husband is before your lordship, marriage at 23 years. Sections are 85 and 118 clause 2. 35
Injury.
Hot water. Pour hot water.
See, my lord, this photograph
No,
for one
no.
person, in which manner wife.
We
was
have
tortured
considered the
with.
materials on record. Petitioner husband poured
Well,
hot
23
water on
years
the
marriage.
And slave
16
in resulting in scalding injuries. Hence, we are not inclined to grant ancillary. What is this? Oh, pouring hot water.
I didn't.
You did it.
I didn't.
No.
I don't have that guts.
Lord, I am for the petition. I am 498A, 306, 304B, 34. Lord, I am the parent-in-law. The husband was arrested. He was granted bail.
We have considered how many years after marriage?
Lord, this,
1 year. This
Will
is the
it-
second marriage of
No.
the victim.
Lord, the lady had married 11 years back.
No, these are in-laws.
My lord.
We have considered materials on record. Petitioners are the in-laws of the victim housewife. Principal accused, that is husband, has been arrested. Victim committed suicide. In view of the aforesaid facts, we are of the opinion custodial interrogation for progress of investigation is not necessary and petitioner may be granted access. Next.
Excuse me. Yes, sure.
50. 50 हो जाएगा.
Please, my lord.
Please, my lord. Well, sibling rivalry, Pawan and Sanjay, two brothers, my lord, spate of litigations, my lord, over a property. These are written communications. But this is unique. Spate of litigation, civil suit filed, withdrawn, second civil suit filed. We file company petition.
Give notice to.
No, my lord, I just tell you, Lord, see the subject matter. The FIR by one of the 42406.
So let us see the FIR.
But page 23, it's in vernacular, it's page 23.
The vernacular, you
No, my lord,
500 page petition, no.
all are communications. I just tell you, Lordship.
But the vernacular FIR cannot be translated.
Or should have been, my lord.
Then-
My apology.
Then
No, my lord, the allegations are
your
that the de
one
facto.
second.
I'm sorry.
উলুবেড়িয়া আমার রিসোর্ট কনস্ট্রাকশনের কাজ করি 46 lakhs আজ সত্ত্বেও আমাকে পাওয়া টাকাটুকু দিচ্ছে না ফুলস্টপ ওকে petitioner submits that there is a commercial dispute petitioner submit that the dispute petitioner submits that there is dispute between him and his brother over construction business. Full stop. He has been falsely implicated. He is ready and willing to cooperate with investigation. He prays for Anticipatory bail. Learned lawyer for the state opposes the prayer. We have considered the materials on record. Gist of the allegation relates to non-refund of a sum of rupees 46 lakhs paid to the petitioner. This is disputed, denied and disputed by the petitioner. Keeping in mind the profile of allegation, we are of the opinion.
But just to assist your lordship, the allegations were he is one of the vendors set up by the brother, saying that he did some work in 2014, 2015, for which the amount was not paid.
As a brother, we আগে বলো যে petitioner submits that ওই first lineটা that there is a commercial dispute between the de facto complainant and the petitioner's firm. De facto complainant has been set up by his brother, another partner of the firm. Allegation of refund of money, claim of repayment is out and out false. He prays for Anticipatory bail. Learned lawyer for state opposes the prayer. We have considered the materials on record. তারপরে ওই gist of the allegations involved allowed. Meet investigating officer once in a week until further.
Well, only, my lords will not take me. I mean, there is no repayment, my lord. The money was not paid against execution of work.
So that is to be repaid. He has to be repaid, no? That's what he says.
But subject to
46
correction.
lakhs.
46 lakhs, my lord, we have not paid.
All right, repayment, na? There is an amount amount to the tune of 46 lakhs payable to the de facto.
Most of like most.
Outstanding to the
Most.
next.
Lordship, for the petitioner, Lordship, the petitioner number 1 has already been arrested. So petition number 2 and 3, I am praying for only. This matter arose.
Petitioner number 1 has been arrested. Application is dismissed as infructuous. We have considered the materials on record.
And one statement is there on the page 45.
Yes, but what is the nature of injury?
My lord, as far as I know, there is no nature of injury as such because the accused 3 was actually hit by.
Savitri Bormon.
This happens to be the petitioner number 1's paternal aunt, your lordship. And there has been several land disputes in between
We
them.
have considered the materials on record. Petitioner number 1, we have considered materials on record. There is dispute amongst family members. Though victim Savitri Bormon was hospitalized, medical papers do not disclose grievous injury. Keeping in mind the aforesaid facts, we are of the opinion petition number 2 and 3 may be granted and suitable. Next. 46.
But I am for the petition, madam. Allegation under section 126, 2, 118, 209 and 35 of the BNS, my lord. the person who has
have considered
attacked, the person who has attacked granted bail.
we have considered the materials on record, including the injury report. Injury does not appear to be grievous. Under such circumstances, we are inclined to grant answer.
He was hospitalized for 9 days.
Homicidal neck injury.
And the injury report says 75.
What is the statement of the victim?
108 crores. Komal and Kamal. Komal was in.
Well, as per FIR, one Chotu has assaulted. He has been granted bail.
Acha, we have considered the injury report. Full stop. Petitioners are not the principal assailant.
But they
Under such circumstances, we are inclined to
My lord,
grant answer.
petitioner, only one petitioner.
Next.
Grateful.
May I please, Your Lordship? My lord, the present petitioner before your lordship, my lord, the wife, father-in-law and brother-in-law. Allegation is that, my lord, the husband.
Murder.
Murder, my lord. What extent? After 2 months, my lord, kindly see.
The postmortem report suggests, my lord, suicide.
Kindly see that, my lord, we started
What is
torture.
38? IPC? BNS?
201.
201, my lord. My lord, we started.
We have considered the materials on record. Allegation of murder is improbabilized by the by the findings in the postmortem report, which discloses death is due to antemortem hanging. Full stop. Antemortem hanging is predominantly suicidal. Full stop. In such view of the matter, we are of the opinion custodial interrogation of petitioner may not be. In such view of the matter, we are of the opinion petitioners may not be necessary and they may be granted anticipatory bail. Acha, tarage diye dao. Petitioner number 1 is the wife of the deceased. Petitioner number 2 is her brother.
Father-in-law and the brother-in-law of the deceased.
2 and 3 are the father-in-law and brother-in-law of the deceased. Hello.
Wait.
But late lordship, I am the state paying not today. So CD has not come yet.
No. What is the offense?
Yes. From
Offense?
307 lordship. 109 of the BNA.
Not true.
Achha.
Next.
Lordship.
Lordship, I am for the petitioner lordship. Allegation under section 117 to 118 to 35 of the BNSS Act. Lordship, there is a
We have considered the
long-standing land dispute between the parties.
we have considered the materials on record. It is contended incident occurred out of a land dispute. Injury report shows injury on the injury report does not appear to be grievous. Under such circumstances, we are inclined to grant answer.
Grateful, Lordship.
Next.
50 million, I appear for the petition.
My lord, I'm appearing on behalf of the state. He is not here.
Let us see.
Subsequently, 364 is also there. My lord,
We have considered
all have
materials
been
on
granted
record.
bail.
Petitioner was involved. Petitioner was a member of the group, one of whom fired at the victim. One of whom petitioner was a member of the group who had kidnapped the victim. In view of the nature of the offense, we are of the opinion this is not a fit case to grant answer. Absolutely dacoit. Oh, they are taking extra.
That's I am for the petitioner.
But I am not holding the case diary.
498 is
We have considered
constitutional of restitution and conjugal rights. Thereafter, this case was
we have considered materials on record. It is contended instant case was registered in retaliation to a suit for restitution of conjugal rights instituted by petitioner husband, keeping in the allegation of torturer general and omnibus. Under such circumstances, we are inclined to grant bail and suitable bail subject to condition, meet investigating officer once in a week and further orders. Next.
Second anticipated bail application, my lord, after charge.
Yes,
After
this
charge
is a second, this is a second application. No, earlier application for anticipatory bail was dismissed on merit. Thereafter, charge sheet has been filed,
Yes, ma'am.
which crystallizes the accusations against the petitioner. Hence, we do not find any extenuating circumstance which would justify entertaining this application for anticipatory bail. Rejected. Next.
53, my lord, I am for the petitioner Arms Act. Charge sheet has been submitted. My lord, co-accused statement. My lord, during investigation, police has.
We have considered the materials on record. What was recovered?
My lord, one ammunition.
Ammunition. We have we have considered the materials on record. One single ammunition was recovered
From my kitchen, pursuant to the
from
leading.
the house of the petitioner. In view of the nature of the accusation, we are of the opinion petitioner may be granted anticipatory bail. Next. 54.
No, West Bengal. His docket has not arrived yet, Lordship.
Very good.
My lord, I am for the petitioner. My lord, petitioner number 1 is the
Order.
father. No, my lord. Actually, it should be my lord 306. 306, my lord.
Yes, that. Tomorrow. 306.
It's okay.
The statement.
My lord, it's 498-302. It's in new act, my lord. It's 85 and 103. My lords had occasion to cogitate on this, my lord. Kindly comes to page 11, my lord. Where the parents-in-law. My lord, paragraph 3. Now I am the paramour now.
Surrender. We have considered the materials on record.
But there is no, but it's everything against the husband, my lord.
So you were the cooperating agent with us.
164 of the daughter is.
My lord, I am.
Materials
Madam, may I just, my lord?
petitioner.
I don't fall within 498A.
You fall within 103.
It's after 14 years, my lord.
We have considered the.
After 14 years of the marriage, my lord. And my lord, kindly see, my lord, when she was taken to hospital, allegedly, the victim made an oral dying declaration. And they implicating the
We
husband.
have considered.
And the husband is in custody, my lord.
Consider the materials on record. Petitioner is the paramour of the husband, daughter of the deceased housewife, alleges that petitioner was present at the spot with a knife in view of the aforesaid incriminating materials and gravity of.
But one
offence.
more
We are not inclined to consider.
statement, my lord. Knife was recovered on the statement of the husband.
Next. We have considered the materials on record. Injuries are not grievous. Injuries are not grievous. Accordingly, we are inclined to grant anticipatory bail. We have considered injuries are not grievous.
57.
Accordingly, we are heard, learned, and counsel for the parties. Boss. Next. 56.
57.
57.
My lord, I am from the petitioner, your lordship. I am led in this matter by my senior, Mr. Arindam Jana. Your lordships, Mr. Jana is currently facing certain personal difficulties, so I'm praying for not today, your lordship. If you can kindly keep it on Monday.
406, 498.
Yes, yes, your lordship.
406 minutes previously. Previously, she used to reside in the matrimonial house. Thereafter, she came.
All right.
After 11 years, there was reunion. Then ex parte divorce. Then this has been.
So, my lordship, ex parte divorce, there was a settlement in the divorce. There was a settlement in the divorce. Thereafter, again, complaint has been filed. In the FIR and the complaint, if you see, your lordship, there has been an allegation of criminal breach of trust, but no list of assets has been provided. The husband is on bail, your lordship. On 10th December, he has been granted bail by the Bidhannagar court. And for the in-laws, I filed this anticipatory bail application, your lordship.
Petitioners are the in-laws of the victim lady. It is contended that the victim had deserted the matrimonial home earlier. Subsequently, the matter was resolved and she returned to the matrimonial home. Allegation of misappropriation, torture and misappropriation of Sridhar articles are out and out false. The principal accused that husband is on bail. They pray for anticipatory bail. And a lawyer for the state opposes the prayer. We have considered the materials on record. Victim lady had an earlier case was registered at the behest of the victim lady. There was a 498A case.
No, no, no.
Acha.
First.
Acha,
Your lordships, earlier there was divorce proceedings.
2012, she separated. Reunion 2023.
Your lordship, if I may, in 2012,
Earlier, victim lady had left the matrimonial home in 2012. An ex parte divorce decree was passed. Full stop. Subsequently, parties started residing together. Allegation of torture and misappropriation of Sridhar article. It is contained in allegation of torture and misappropriation of Sridhar article are false. Principal accused, that his husband, is on regular bail. Keeping in mind the aforesaid facts and the extent of involvement of the petitioners, that is the in-laws in the case, we are inclined to grant anticipatory bail.
The only problem is they have not complied 41. Otherwise,
They do not require to comply 41. Next.
Much obliged, Your Lordship.
Wait, please, Your Lordship.
I don't receive.
Lordship, petitioner got a piece of land from his mother, deed of gift, that is page 17.
Not today, not today.
Huh?
Next.
Can it be Monday? I can get this. Tomorrow I will get Monday.
Monday. 59.
Lamb for the petitioner. But allegation on the section 341, 325, 326.
When was the proclamation?
Other quaker granted anticipatory bail, page 8, my lord.
Petitioner has absconded and has been declared as a proclaimed offender. In view of the aforesaid fact and the materials implicating the petitioner in the crime, we are not inclined to grant anticipatory bail. It is open to the petitioner to appear before the jurisdictional court and pray for regular bail in accordance. Next. Here.
My lord, 109. 109, husband, wife, and daughter. These three were added as accused. Husband and daughter was granted anticipatory bail by the learned session judge. Now, wife is before your lordship. Allegation is she has ingested kerosene oil in the mouth of the victim. Now, she
Not
was
today.
in
Let us see what is the statement.
was in hospital for 1 day only.
Maybe, but
Maybe, I
if the
understand.
allegation is that
No,
you
I
have put kerosene oil, you have to surrender. Next.
My lord, I am for the petition. The husband is on bail. After 8 years, she committed suicide by hanging. This is the husband is copied. My lord,
we have considered the materials on record. Husband has been granted regular bail.
And PM report says the case of hanging.
It appears that the victim housewife died due to hanging, which is predominantly suicidal. Petitioners are the in-laws of the victim lady. Allegations against them are general and omnibus. Accordingly, we are inclined to grant answer. Next.
Lordship, I don't have CD, received it today.
Let us see.
But allegation section 307, 325, 34, 379,
We
447
have
old
considered
section.
the materials on record.
Fist and blow. The petitioner and 7 others.
You have considered the materials on record. Petitioner had assaulted the victim on the head and she had been referred for further treatment. Keeping in mind this fact, we are of the opinion and nature of offense, we are of the opinion this is not a fit case to grant anticipatory bail. Next.
But the de facto complainant, my lord, is the brother-in-law of the petitioner number 2. My lord, between the petitioner number 2 and his sister, there is a dispute over ancestral property. Now, my lord, he alleges that we are.
Which first state?
But he alleges that we are residents of Gagnapur, he stays in Chagda.
Is case diary? Not today. Next.
Out of romantic relation, victim eloped with this petitioner. But subsequently, she has been recovered.
We have considered the materials on record. Make the victim a party. Victim be added as
365.
victim be added as a party respondent. Officer in charge shall notify the victim with regard to the pendency of the proceeding and a right to legal representation. Under such circumstances, matter will appear 1 week after vacation, keeping in mind the nature of the case. And as victim has been recovered, we direct petitioner shall not be arrested 2 weeks. Next.
My lord, I am for the petitioner. 66, I am for the petitioner, lordship.
Yes. Victim has to be notified.
Lordship, notification service is done.
Yes, we have considered the
Delivered.
materials on record. Injury. Yes, injury report.
On page 34. And there is a 164 statement, my lord, Manasi Das at page 30.
Page 30.
I should say, we have annexed the title suit, civil suit is going on, and our case is first. We were assaulted, lordship. The person, Bablu Jana, who assaulted the
petitioner number 1.
he also received grievous injury. P4 is title suit, and our case is 550. Their case is 552. Over the civil dispute quarrel.
Purvogiri, Pulingiri, Onilgiri, Misagiri,
Olokagiri.
Olokagiri.
My lord, Apurvo, my lord, investigation. Pulin, my lord, I did not find anything, my lord. Onil is, my lord, the assailant. Misagiri, my lord, there is nothing. Olokagiri is the assailant. Because there are 2 injured persons.
Alaka we are rejecting and Pulin we are rejecting.
And other one, my lord.
Apurvo, there is no allegation.
Onil,
Huh?
Onil, my lord, assailant.
Sorry, Onil we are rejecting.
Onil and Olka is my lord.
Oloka we are rejecting. Petitioner contends that there is dispute between the parties. Case and counter case were registered. They pray for anticipatory bail and a lawyer for the state and de facto complainant opposed the prayer. We have considered the materials on record, including statement of the injured. It is alleged petitioner number 3 and 5 assaulted the victims, keeping in mind their primary role in the crime. We are not inclined to grant anticipatory bail. Rules against allegations against 1, 2, and 4 are general and omnibus. Possibility of false implication due to prior enmity cannot be ruled out. Accordingly, we are inclined to grant anticipatory bail. Next.
The 68, my lord, I am for the petition.
Section.
68, I am for the petition.
Section.
The allegation is under section 126, 181, 2, 109 of the BNS.
Tomorrow you'll bring the case diary? Tomorrow, not today.
About the petitioner, my lord, allegations are under section, my lord, old case, my lord, 325, 307, my lord. I am the mother, the principal accused. It's a mother, my lord. I'm the mother, my lord. Principal accused has been already, my son is the principal accused. He has been already taken into custody, my lord. And another, my,
Yes, well, let this matter appear 1 week after vacation. Case diary with injury report be produced. Petitioner contents she is not the principal accused. Petitioner shall be under such circumstance in view of this submission. Petitioner shall not be arrested 2 weeks or until further orders, whichever is earlier. Next.
আজকে এই দুটো হয়ে গেলে কালকের গুলো এনসিবির আছে ও করে দেবে আমি আচ্ছা এইটা
Petitioner is 20 years old and a student of a college. But our parents are on bail. After 50 years, therefore bail has been allowed. But on 3rd September, he was hospitalized and 20th September, he expired.
We have considered the materials on record. Petitioner and others assaulted the victim, resulting in hospitalization. Co-accused have been released on regular bail. In such light of under such circumstances, we are of the opinion this is not a fit case to grant anticipatory bail. Next.
I am appearing for the petitioner.
72.
It's related.
307. Not today. Not today.
Yes, sir, my application, Lordship. 302, Lordship. 302, Lordship.
You have considered materials on record. Petitioner is named, it is day after tomorrow, Monday.
Lord.
Monday. Next. Your name.
74. Not pressing.
Next.
But I'm not pressing.
Why do you file? Why not press? Hello, your instruction, we reject the application. If petitioner does not wish to press the application, not pressed. Dismissed, not pressed. Not inclined. Grant of bail stands on a different parameter to that of pre-arrest bail. Next.
Mortgage note from the husband of the recapture complainant, 6 my lord, and there are card payment has been made.
All right, my lord, we have considered the mechanism.
Milord, I have to say something. Milord, I am happy with defective complainant, Milord. Money he has taken, Milord. I have no other money by myself, Milord. I cannot come to the court due to you have to pay, Milord. Pay the money. Please, yes. I paid 80,000 is due, Milord.
Let the repayment stop. And he has not complied with the 30.
Payment has been made.
Let us do like this. If you are in a position, give some money by way of bona fides. Can you show bona fides and give money? Take instruction. Petitioner contends that uncontroverted allegations disclose at its height disclose not non-payment of a loan. Against what loan was taken? Mortgage, they are saying?
Mortgage loan, my lord, or deposits, my lord. Is the deed of house, my lord. Deed.
Execute that deed. Get that deed.
Petitioners, against that, the loan was taken.
The fixed deposit is attached.
Must be them, my lord. The fixed deposit.
You have the fixed deposit.
Fixed deposit আপনার কাছে?
Who has encashed it?
Money was three. There are two more. By two check, by left is not by cash.
So with loan amount, madam, loan amount is no ground to reject anticipatory bail. Can you show that against what security the loan was given? The mortgage of what?
His house, petitioner's house.
Petitioner's house. So you exercise your powers of mortgage. You foreclose the mortgage, take possession of the house.
Deed has been given, nothing.
So that is exactly how a equitable mortgage is created. Mr. If there is an equitable mortgage, how can you do it? Madam, we cannot indulge you. You very well know how you can you exercise powers of equitable mortgage. Go ahead and do it. Petitioner.
He admitted that 2 lakh.
Correct. He admitted file a judgment on admission. This is not a place for recovery. That is exactly what we are trying to say, that she's already secured by an equitable mortgage.
It takes time that I have no money in that.
So kindly direct to say give me some money.
Petitioner contends that a mortgage, submit that a mortgage, a loan was advanced against mortgage. He has partly paid the loan. There is no ingredient of cheating or criminal breach of trust. He prays for anticipatory bail. Learned lawyer, de facto complainant appears in person. She submits that that petitioner admitted the dues and is refusing to pay the amount. Learned lawyer for state opposes the prayer. We have considered the materials on record. Loans were advanced by creating by creating mortgage against immovable property. It is open to the de facto complainant to exercise her powers or exercise her rights against the mortgage property. Part payment has already been made. Under such circumstances, we are of the opinion custodial interrogation is not necessary and petitioners may be granted anticipatory bail subject to condition. Petitioner number 1 shall meet the investigating officer once in a week until further order. Next. Lawyer, you will have to do the very next.
My lord, I am appearing for the
General 4B within 3 years of marriage.
Then make it not today.
Not today. Case date. Next.
After 14 years, husband committed suicide.
We have considered the materials on record. Victim, petitioner's husband committed suicide after 14 years of marriage. Keeping in mind the facts and circumstances of the case, we are of the opinion, full stop. Case diary be produced, state shall produce case diary on the adjourned date. Matter will appear 1 week after vacation. Keeping in mind facts and circumstances, we direct petitioner shall not be arrested for 2 weeks or until further orders, whichever say earlier. Next.
80, my lord, I am for the petitioner, my lord. There is a altercation took place regarding the collecting leaf of the due to his cow feet.
Collecting leaf from cow dung.
Cow feet. Cow feet of the petitioner.
What is cow pit?
Well, some collecting leaf, sugar cane leaf.
Sugar cane leaf. Injury. Ego. State. What happened to Prabhas?
He was here, my lord.
Not today.
Fine.
Next.
My lord, I will be praying for a day's accommodation, my lord. 300.
Not today. 83.
My lord, I am for the petitioner, my lord. My lord, 118, 109, 307.
What is the injury? We have considered the material record. Injury report shows injuries are simple. Under such circumstances, we are inclined to grant answer. Allow. Next.
I am for the defect.
84. 84.
84 days, Lordship, my please. Lordship, that is in 448.
We have considered the materials on record.
201.
Petitioner's husband was abducted by the petitioner. Petitioner's victim, de facto complainant's husband was abducted by the petitioner and thereafter murdered. In view of the gravity of the offense, we are not inclined to grant answer. Next.
But as for the petition, my lord, allegation of illegal transportation of coal, my lord, which was not correct. Coal was, my lord, sold by one Joy Matara Enterprise, my lord, to one Brickfield in Lalgola. But after giving proper challan, page 11 is the, my lord, through the petitioner. I was not.
Any criminal antecedent?
Nothing.
Well, page number 11 is the challan.
Challan. Petitioner submits that he was transporting coal against licit challans. Full stop. State shall submit report with regard to the verification of the document, with regard to the authenticity of the document. Report shall also disclose criminal antecedent, if any. Matter will appear 1 week after vacation. Petitioner shall not be arrested in connection with this case for 3 weeks or until further orders, whichever is earlier, on condition he shall meet the investigating officer once in a week and further orders.
Grateful.
Grateful. Deep love. ঠিক আছে, ভালো অর্ডার করে দিচ্ছি।
husband.
It is, my lord, I am for the petitioner, my lord.
No, not today.
Tomorrow it has been solved.
So what?
From Malda.
Monday. Next.
But 420, 406, 1 year after the alleged incident, 156.3.
420?
420, 406, 156.3 lost 1 year. My lord, I have complied with the, my lord, 41 notices. Allegation is agreement for sale was executed, but the conveyance was not been, my lord.
All right. Petitioner submits that there is a that the dispute is civil in nature and has been given a criminal profile. He prays for anticipatory bail and a lawyer for the state opposes the prayer. We have considered the materials on record. In the FIR, it is alleged that a sale agreement was executed between the parties and part payment was made. Thereafter, the deed was not. Thereafter, the sale deed was not executed and registered. It is contended that the de facto complainant failed and or neglected to pay the entire consideration sum. This issue requires to be thrashed out before the appropriate forum in accordance with law. However, custodial interrogation for progress of investigation is not necessary and petitioner may be granted anticipatory bail. 10,000 issued. Next.
It remained page 40. I am on the same footing with the co-accused granted anticipatory bail.
Consider the materials on record. Co-accused has been granted anticipatory bail. Petitioner stands on the same footing and may be extended similar relief allowed.
Lord, 91 Lord, I am for the petitioner. 108 of the BNS Act. Lord, after 8 days, Lord, complaint was lodged.
I did note you, Lord. He has named the petitioner and everything.
About the
if I-
9 lakh, that was the return, Lord, out of frustration, Lord, the husband of the petitioner, husband of the Lord, complainant committed suicide, Lord. Kindly see.
Husband?
Yes. After 8 days, Lord, complaint was lodged.
The materials on record. Statement, suicide note of the victim implicates the petitioner in the crime. In view of the aforesaid incriminating fact and nature of offense, we are not inclined to grant anticipatory bail. Next.
92. I am praying for not today, my lord. His date is not yet arrived.
Offense.
This is the second FIR over the same incident. Second FIR over the same incident.
Again.
Lord, the sections are 406.
Like tomorrow. Which is 406?
Sorry, my lord, this is the wrong one. My lord. This one. 92. 126, 115, 117.
Assault case. Next. You're getting too many briefs.
No, my lord. Same petitioner, my lord, 4 things. But
4 cases.
Took out the wrong one by mistake.
All
I'm
right.
extremely sorry.
Who is for state in this matter? So bring the case diary, also criminal antecedent. He's saying number of cases are there against you.
My lord.
Next. 94. 93.
I am for the petitioner, my lord. I am for the
Owner?
The owner of the vehicle.
And
the driver and one of the person they fled in it.
So A.
Transportation
Of sand.
sand transportation.
Sand. We have considered materials on record. Petitioner is the owner of the vehicle which was used for illegal transportation of sand. In view of the nature of crime which partakes an organized criminal activity, we are of the opinion custodial interrogation is necessary and this is not a fit case to grant answer. Go to custody. Each owner driver will go to custody.
But I am for the petition this matter, my lord. The allegation.
Monday.
Yes, my lord.
Next.
Lordship, 498.
Only?
No, my lord, 313 is there, Lordship.
Well, we have not received. Apurva Datta, anticipatory bail 498, rejection for 313. Let the case diary come. 313, what is there?
Lordship, kindly keep it on Monday, Lordship.
Monday. 96.
I am for the petitioner. My lord, 117(2) and 118 of the BNS Act.
Who is for state? We have considered materials on record. Nobody appears for the state. Yes. Case diary. Not today. 97.
97, my lord, I am for the petition.
Section.
My lord,
466, 460, 470, 415 and 120.
my lord, civil suit is pending. My lord, our claim is that, my lord, we have got the property from one series, and my lord, complainant in this case is that, my lord,
98.
Lordship, 98, I am for the stay. I have not received the CD, but
Lordship,
16,
Lordship, and 302. We have considered the materials on record. Petitioner absconded for 8 years. There are ample materials against him under such circumstances. Against him, ample materials implicating him in the murder. Under such circumstances, we are not inclined to grant. Next.
I am for the petitioner, my lord, must kindly see my page 10.
Page
Must
10
kindly see
what?
page 10. My lord.
What is page
Other
10?
16 co-accused granted anticipatory bail. The injury report not grievous, my lord.
All right, we have considered the materials.
Page
on
10,
record.
last second, last slide.
Petitioner is in petitioner contents. Co-accused have been granted anticipatory bail. Petitioner stands on the same footing and is entitled to similar relief allowed. Other matters tomorrow.
Grateful, Lord.
next one was mine.
100,
Next
100,
one was
century.
Next one.
Come century, century.
Only after century.